you co-host to be able to present. So you'll see those pop up as people join.
Great.
Okay, well, let's get started. So be respectful of everybody's time. Thank you so much for joining us today. This is always a great opportunity when we host these education webinars. I'm super appreciative, and I'm very, very appreciative of my partnership with Sonja Borda, who is a certified financial planner and certified divorce financial analyst. She's a trust advisor at Hancock Whitney, where she's responsible for managing trust and asset management relationships for high net worth individuals and families. She's been a member of Hancock Whitney for 1 year, with 17 years in the industry itself. And prior to joining Hancock Whitney, she worked at Wells Fargo, Fidelity Investments, Baker Avenue Wealth Management, and most recently a financial planner with Mercer Advisors. Sonia takes great pride in her ability to build long-term relationships through creative solution thinking, which I do appreciate very much in our trust relationships, our trust partners, and intersecting logic and detail and practicality with common sense, and customized planning for our clients in terms and areas of financial planning, risk management, investment, tax, debt, estate, and retirement planning. And where Strada partners with trust companies is, for example, right now we have a client who just built a very complex estate plan, left their children as the primary trustee, which is a logical good step. And then we are now vetting out trust companies as a secondary executor to the will for an estate. So this can always be a really good fit in working with any financial planner, any estate planning attorney, anyone of your trusted advisors, CPAs, to think about how to work in a trust relationship if you ever need a backup to your own planning. Sonia is a graduate of Texas Tech with a bachelor's degree in human development, family studies, and speaks Spanish fluently, which is very, very impressive. I'm on 500 days of Duolingo. Spanish, a nice job, and is former treasurer of the Rotary International and a wish granter, which I would love to hear about sometime, for Make-A-Wish Foundation. So thank you so much for joining us. Welcome, and I will hand it over to you.
Great. Thank you so much, Jennifer. I'm delighted to be here. It looks like we have Sandy today. Hello, Sandy. Nice to see you, at least in name. And really, Jennifer and I had talked earlier, and this is a question that she gets a lot around trustees and what that should be and what to consider. And so really my goal in speaking today is to just give you an overview of, what are the duties of a trustee, what is required, what should be considered, etc. So before I get started, though, I'd like to know, Sandy, do you have any specific questions, or anyone, do you have any specific set of questions you want to make sure we answer during this time?
No, not right now.
And
this is a big topic, and every little bit of knowledge I can get is helpful.
That's right.
Wonderful. Right. Well, it's always good to have more information so you can make a most informed decision. And so I will kind of proceed here. Really, let's go back to the basics, because I think we so often make assumptions about what we understand or don't understand. And so my first step is going to be to kind of level set and say, what exactly is a trust? Why would you do it? What are some advantages? And then what are the duties? I think as Jennifer talked about, the family member being named as trustee and maybe looking for some backup support, that's a role that can be really important. That'll become more clear as we look at the duties of the trustee. Also, that the folks who establish trust, in Jennifer's example in particular, are, my clients are people whose wealth will outlive them. They will not exhaust all of their wealth in their lifetime. And so we need to see what will happen next. And that's what trusts provide. So just giving a kind of a simple way to look at it, a trust essentially is, we'll just call it, it's a box, okay? Not everybody needs a trust. Not everybody's family situation would be, best for this. So, but if, all of us have ordered, probably too many Amazon deliveries, right? Well, think of a trust as the box. and there are instructions that come inside of those. Okay, and that's the trust document. So let's look at the party. So in a trust, there's a grantor. So the trust has to be established. The grantor established the trust. There's a trustee. Now the trustee is the one who owns the box. Okay, that's their property, is the box. The trust agreement, the instructions inside of the box, and the beneficiaries are who gets what's inside of the box, because the trustee generally doesn't benefit from that beyond their lifetime. So they're current beneficiaries. So the trustee. So in a lot of trusts that I work with, they're all one and the same person. The grantor, so husband and wife establish a trust, so they're the grantors. They are the trustee while they're alive, and so they get to determine what happens with the box and everything in it, and they're the beneficiaries, so they get benefit from the trust as well. And so everything in that gets to be managed for the current beneficiaries, but then who comes after them? As I said, my clients have more wealth than they will spend or exhaust in their lifetime. So we're also considering the remainder beneficiaries. Does anybody have any questions about the parties of a trust or what a trust is?
No, and if at some point you could talk about, I think you're going to talk about duties and responsibilities of the trustee, right?
Yes.
And when you do what you mentioned, a common question that comes up is how much a trustee should get paid to manage a trust.
Good question. Yes. So let's talk about what's in it. So in the box, I think probably the most common things that are in trusts are investments, cash, stocks, bonds, etc. But often there are maybe real estate assets. Maybe there's a family farm. Maybe I'm working with some clients who are 7th and 8th generation mineral assets, right? And those get passed on from generation to generation. So what property trust can hold is also something important to consider, what the family has. So if we're just talking about investments, and some people, most people have retirement accounts, investment accounts, etc. I'd say that investment management is really the most common asset that we see. And if that is what we're managing, then there is kind of a base fee for that. They've tiered based on the amount of assets. In working with me as a trust advisor, my minimum assets inclusive of real estate, oil and gas, and investments is $3 million to be able to work with these clients. And if it's just investments, the assets under management is around 1%, given the different tiers of the amount of investments. And then if there are additional assets that would include real estate, oil and gas, etc., there's or trustee services, if you're engaged for that as well, then there's an addition on top of that.
Awesome, thank you.
Get a good start. Okay.
Yeah, perfect.
So there are really three parties. So the grantor, the trustee, and the beneficiaries. Super basic, but it's important to level set and be sure that we're kind of on the same page. And sometimes and I think most commonly, the trustee that's named is somebody who's a family member or a friend or a CPA or an attorney for the beneficiaries. But I think the thing that had me really want to prepare this and really start talking to people about it is that who's the trustee is really the most important decision you can make, because if you choose a trustee who is family or friends, as most people do, there is a risk to be aware of, and that risk is that it can harm relationship with the rest of the family, and that is an unintended consequence. So it's important to think about. For example, I have a friend and colleague who's an attorney, and she ended up serving as trustee for her best friend's children. They all now hate her because she can't to make distributions for all of the things that they're requesting. Because the instructions in the box, the trust agreement, say that she can't. And so it puts her in a bad situation. And some objectivity or backup would have been good in that case. So why would we do a trust? Well, we do a trust if we need to protect the assets, provide shelter from them. Are there is there concern about creditors? Is there concern about risk of lawsuits or something like that? A lot of the clients I've worked with who have significant assets are concerned somebody's going to try and take them by lawsuits. And so a trust can provide protections. What about contingencies? What if there is incapacity? What if someone is unable to care for themselves, or there are minors involved, there are children and grandchildren involved? What if somebody passes away untimely? Then what? The trust would provide for contingencies and to maintain the trust in force beyond your own lifetime. Absolutely no one survives life, right? But no one knows when it will begin or end. We don't get to choose that. But for a trust, it's a legal document. You're creating a box that does have a termination. You can determine when it ends. And so that's important. Also, it can account for children and grandchildren that you don't even know are coming in future generations. And so it can also allow for additions to the trust. So any trustee is going to have something called pre-acceptance, to where we will need to review whatever assets are being held in the trust. For example, I mentioned that we could hold real estate. We probably won't take property in Chernobyl, right? That's probably not going to come into our trust.
Is there an acceptance policy that you guys use to help clients understand what you do and don't take?
Yes.
Okay.
Yes. So, for example, we do have cotton farms. We do have, and I work with clients who have cotton farms and timber, and so there's a variety of things that we will allow, but we may not take, for example, a dry cleaner because of the risk to the environmental concerns. The chemicals leach into the soil, so it's very much case. That's a great question, and there are always exceptions that can be made. And I'm the advocate that would make kind of the exceptions and present that. Okay, so this, I think, is a meat of this discussion today. The duties of a trustee. What is it you're asking of your family or your spouse? Okay, well, they have to read the instructions in the box, first of all. Now, they have to manage investments, assuming we have, stocks and bonds, etc. They have the will, skill, knowledge to manage the investments. They also need to make disbursements. Okay, here's something to understand that you may not know. When you think of the things in the box, you've got principal, so that, let's call that a share of Apple stock. Okay, and then you've got the capital gains and the income. So you've got principal and you've got income. And trust documents and the Texas Trust Code has provisions for what should, can, and must be distributed of income and principal. And so understanding what the differences are and what is required to do with income or with principal is really important. Also know that trustees can be sued. So your family member could be sued for not doing it right, even if they don't know what the difference is. So having backup can be really nice and very helpful. So making payments to the beneficiary of the trust is a trustee responsibility. Keeping all records and accounting is required. Trust accounting can be required by the court. And then you need to provide that to the court, and there's specific requirements about what that is and how it looks and what's allowed and what isn't. Preparation for fiduciary tax returns. If you have a trust, you will file a 1041. It is, I'm doing that right now with a lot of our clients. As we can, engage we provide that trust tax filing, or as trustee for, family or spouse, they would need to engage an attorney or engage a CPA to provide a 1041 filing, which may have a K1 that goes back into your individual tax filing. So a trustee also has to provide custody and safekeeping of the assets, and is required to provide financial advice to the beneficiaries. Does your trustee have the training and education to provide those resources to the satisfaction of the beneficiaries?
And I think the duties alone, for people that are thinking about leaving a trust, especially for the benefit of a child or a grandchild, looking at these duties alone should cause everybody to pause and say, do I have does my trustee, proposed trustee, have the capability, like to your point, of being the fiduciary, having the arm's length capability, administering the trust, and having the proper training to guide the assets within the trust. So I think this is why we talk to trusted partners like Hancock Whitney, for this exact reason.
Exactly, because this is what we do, every day.
Right.
And then to meet with beneficiaries ongoing, because as all certified financial planners know, we need to monitor and adjust the plan. Things change in life, and we need to make the adjustments accordingly. And so meet periodically with the beneficiaries, make updates to what's needed. Whether it's the payment of the mortgage has increased because of property tax insurance increases, or whatever that is. And then to work with the advisor on the trust, there may be another professional like Jennifer that we would work with in collaboration to ensure ongoing, we're all on the same page, managing for the best interests of the client. Mm-hmm. So we could serve so most of my clients are, they have a trust set up already, and husband or wife or family member may be trustee, and we serve on what's called an agency basis. So I take your direction on who to distribute to, etc. And that, I would say, is the most common. We can also serve on a fiduciary capacity. So as Jennifer mentioned, maybe there's a child involved, or there's or it's second or third generation involved. We can serve as fiduciary, special needs, for example. We can serve as a special needs trustee, etc., and take on all of these responsibilities on our own, or we can serve as co-trustee, which would be backup. So the family member, the brother, the sister, the spouse, we would serve as co-trustee to provide advice and step in when desired. We would also do all of the accounting, right, for the one with whom we're serving as co-trustee.
I was going to say, here in this, for the special needs trust, an amazing use case is if you have a family that is establishing a special needs trust, under no circumstances should you not have a trust company. Like, this would be one of those times where I would say it should not be a family member. It should not be somebody that you like, or, I mean, it really does need to be a trust company. We name trust companies all the time with special needs trust, especially pursuant to a dissolution of a marriage, or, if clients are divorcing and they have a special needs child, you can partition assets to fund the trust and then name your trustee, because even though the parents they might be on good terms during the process of the divorce and with the best of intent to fund a special needs trust for the benefit of the child, you just don't know what will happen in 5-6 years as things change. And so it is truly, like, that is a use case where I would never not have a trust company.
Yeah, really important to have objectivity So picking who the trustee, I guess I kind of already spoke about this. So you could have a corporate trustee, like you said, and that provides objectivity. And so when we serve as corporate trustee, we essentially have a giant target painted on our back. Okay. And so we won't do anything that is outside of the terms of the trust. Okay. We also, though, have attorneys on staff for either our agency or as a fiduciary, say in a special needs situation, that I can bring in and provide advice about what the trust document says, bring them in. If something needs to be amended or revoked or changed, we'll do that internally, and then you'll save money on legal fees because you already have the answers, okay, before you meet with the attorney. And so that can be really valuable. So, you know, just as backup can be really helpful. So these are the main considerations of whether you would do an individual or a corporate trustee. Lots of advantages to naming spouse or siblings or family. But the disadvantages is nobody knows who the corporate trustee is going to be. I serve as corporate trustee. I'm the one who you would work with. And so I think that's valuable to know if there were a level of comfort in making this decision that's available. Different companies do it different ways, and there may be an 800 number, or there may be some other process that is in place. And so maybe, you know, it's possible to mitigate some of the disadvantage if you have a relationship with the person who's serving in that capacity. Some other considerations on having a corporate trustee. There's some advantages and there's some disadvantages. Kind of spoke to some of those. The disadvantage here at the bottom says no backup, right? So what if the individual trustee becomes unavailable? Or
this is actually where I do tell clients, I understand that you want to have an individual trustee because some clients are adamant about that. And there's, you can talk to them all and try to educate. But then what I tell them is you have to have a backup. So, and candidly, I actually tell them they still have to pay their individual trustee for their time as well. You know what I mean? Because there's a lot of work that goes into being a trustee.
Oh, yeah.
Yeah.
There's a lot of work with it and a lot of liability. And, if beneficiaries don't like it, there can be lawsuits, but also, I mean, the cost, the legal cost, right, of this can be huge because, anybody can be sued. Now, what if the trust agreement, the instructions in the box only allows for one or two trustees, husband, wife, brother-in-law? Okay. Well, what if they all say no, thank you, and they decline to serve? Then what? Yeah. In the situation that I talked about with my friend who's an attorney, she named 4 people. The trust document named 4 people. She was
said no,
and she knew that, and so she, she did not decline to serve because she knows the consequences. And here's what happens: if 3 people, husband, so spouse, sibling, and in-law are named, and they all say, no way, I'm not taking on this risk, I can't do it. Okay, then it has to go to court. And the judge decides. Yeah, which is frightening. Never let a judge decide your fate. No, I mean, and then it could be like, Bank of 1-800. Right. So there's no, you lose complete control. So the question of cost, let's consider that again, right? What is that? And what would you like? But make sure if you're drafting a trust, if you've decided this is the right thing, make sure you have flexibility because you don't know what's going to change. Okay. And so allowing the documents flexibility to revoke the trust, to change trustees, to add new trustees, to have a way to to move forward, because you don't want a judge deciding. I mean, maybe you do. That's an assumption, but I don't believe you do, right? Because you don't know what that would be. So if oversight, backup, risk management ongoing is a concern, you can even name, Hancock Whitney as a possible, okay, in the documents, so that if there is a question, they'll just contact our trust department. That happens, too.
They do
So
that without let me ask I know the ethical answer is they should tell you if they're gonna do that. But have people named Hancock Whitney as trustee without telling Hancock Whitney in advance?
yes, they can
Okay.
do that. Sure. And then, an attorney would contact us and say, I have a client that we're probating an estate, etc., or whatever the case may be. Okay, and then we'll come in and serve, and somebody will be assigned. So that's why a lot of our clients have accounts with us now. They're in their 50s or whatever the case may be, and they've established an investment account with us now, right? So that we're the ones then to contact the beneficiary. So we can serve as executor on the estate if we need to. I have a client, it's not my client, it's a client of a colleague of mine who is administered, the real estate was owned as a part of the trust, and they just did an estate sale, okay, for all the property in the house. And that's something we do. For clients, another kind of in between area that I think serving as corporate trustee can really help with is we all plan for living and being able to produce or live off of income, but when the incapacity happens, and it's not, they can still feed themselves. They can still, that they don't have long-term care insurance. It's not a trigger for that. What about in between? We have clients that we serve as trustee. There may be mental illness. There may be somebody's been incarcerated or something, right? And in the meantime, serve all of those functionalities. So those are considerations. I would say that it's all about, so if your assets are going to outlive you, okay, then you're really talking about legacy. Whether it's charitable or for family or whatever that looks like, you want to make sure there's a smooth transfer of wealth. Prevent conflicts. Let's help you prevent conflicts if we can foresee them. And really, tax liability, probate, and expense management, I think, are kind of keys there. And that's why, we do financial planning as well. I imagine, Jennifer, that's why people engage you in the first place.
Yeah.
We're kind of aligned there. And so, our process would be, of course, Jennifer would create, a financial plan, determine a need. And then when if there are trust accounts, one of the biggest problems we see is people do their financial plan. They do their estate planning, but then they don't fund their trusts. Okay, well, let's fund them, right? Get the trust accounts established and include the assets that were stated in the estate planning document to fund those.
Can you slow down? Because when people hear fund the trust, everybody shuts down, like I've noticed. They'll open up the trust, they get all the legal documents done, and then they never put anything in the trust. Can you walk us through what that looks like so people understand it's not as scary as it sounds?
That's such a good question. Yes, of course. Okay, so if I have ABC Trust, then what I have is a box. I have not put anything in the box. Okay, it is an empty box. It might be pretty, but it's empty. So in order to fund the trust, that means you need to have an account that is established in the name of ABC Trust. And 90% of the time it's an investment account, right? So ABC Trust is the name on the trust, like your name is on your bank account, okay? ABC Trust is the name is titled on that account, and investments are held in that. If
Just
you're
to further debunk it, it's basically calling your Schwab or your Fidelity or whomever,
Yeah.
providing them with the legal documents so they can open the account titled in the trust name so they can start to move the assets into that account, right? I want to make sure everybody's got a level set on it.
Yes, that's right. So the Schwab account, we need to say ABC Trust. And that means it gets in the box. If it doesn't have ABC Trust on the account, it's not in the box. It's outside in a tote bag. But it needs to be transferred from outside into the box. And putting the name of the trust on it says it belongs in the box. It's legally included in that box. Nothing else that doesn't have that name on it doesn't get to go in the box. And so the accounts need to be funded, whatever the investment plan is, etc., managing taxes. Now that it's in the box, there's going to be income and there's going to be principal. There's going to be, the tree and the fruit, right? And so there are different tax consequences associated with tree and with fruit. And that needs to be accounted for in the 1041 and managed appropriately. And then ongoing, continuing to monitor as beneficiaries change and life comes and goes and the different things happen. So of course, there's monitoring on daily, monthly, quarterly, annual basis, statements, etc. So you can tell a trust is funded if you have a quarterly statement that says ABC Trust and that statement has Apple stock in it or whatever the case may be, then that's how you know you funded your trust.
Thank you.
Sure. So so just a note about Hancock Whitney, we have about 100 years in this space. You may not have heard of us. We're kind of the best kept secret in Texas because we are a Gulf South bank. We started in, many of our clients come from Spindletop, for example. So they've been with us for many, many years through New Orleans. If you are from New Orleans or know anybody from there, we sponsor New Orleans Saints. We've been around there for many, many years, and we're expanding into the Texas market. We recently acquired Capital One's, and I guess maybe about 5 years ago, Capital One's trust business in the area, and that gave us a larger footprint, and we're continuing to expand. But the assets under administration is 35 billion, so we're a large company. We're 4,500 employees or so. So you may not have known we exist, but we certainly do. We do have an Austin location, and I go to meet with clients in Austin. I will be there on April 10th, meeting with a client to review her trust document and get her. She didn't have the benefit of Jennifer to do financial planning, and so we can provide that on her behalf as well.
Great.
So we're certainly local and can be local and in the area as well. And so we have investment. There's several folks we have a large team, I guess, so to speak. What I like is this chart because it really shows, and I might just even zoom in a little bit to see this a little better. I serve in the trust, estates, and specialty assets. So personal trust services as a trust advisor, this is kind of my home, but all of our clients, need other things too. So maybe there's a business exit, maybe there's wealth transfer tax that we're looking at. Maybe they have a business, need commercial lending, private banking, portfolio management, all of that.
Awesome.
Are there any questions that anyone has?
I have a lot of questions. Have you had people call you and ask to put crypto in the trust?
Oh, very good question. Yes, I have. We would not, in our pre-acceptance process, we wouldn't accept crypto.
Not even a Bitcoin or a Ethereum Lite or?
I don't believe that would be something
Yeah.
we would accept. Good question.
Yeah, there's a lot of dialogue about gift acceptance policies within charities right now on acceptance of crypto. So I'm just curious what the trust companies are doing. Is that across the board or is that a Hancock Whitney thing? Have you heard of other trust companies accepting crypto?
I have not heard of any trust companies accepting crypto. Doesn't mean it doesn't exist. I'm not
Right.
on mission, but I do not have any clients, nor do I know of any other clients at Hancock Whitney that have crypto.
You talked about certain businesses like dry cleaners and stuff. Is there real estate you do? What about foreign real estate? Is that something that Hancock Whitney would accept into a trust?
We will review it. There's a review process, and if there are compensating factors, then there's wiggle room. The analogy that comes to mind for me is, you want to have a relationship developed in advance of any of these, significant changes happening. Kind of like, you don't look for a cardiologist when you're having symptoms of a stroke, right?
Right.
You'd like to be, and when that relationship is established, then there's more flexibility around what can and cannot be accepted in the trust. So it could be, the answer might change to could be if we have a relationship. So there is some flexibility there.
Great. I have found in the past too that when we do these calls, people always think of questions later. So I just want to offer Sonja up as a resource. And when we post the call, the follow-up on LinkedIn, I'll be sure all your details in there, Sonja. And of course, people can always come to me with trust questions as well. I don't always have the answers. If I don't have my call, Sonja.
All right, yeah. Well, I'm happy to be a resource to anybody. Any question that you would like to ask, I'd love to answer for you. And just make sure that their stakes are really high with what we're looking at when there is legacy on the line. And just to have a thinking partner or a sounding board, I'd be delighted to serve in whatever way you'd find beneficial.
I just recently heard somebody say, you build a trust or you create a trust when you don't trust. And so I know that's a very dark way of looking at it, but it is very apt advice. If you're a parent or grandparent and you don't trust the way things will, your wishes and or legacy or assets get disposed of post death, then a trust could be a really good option because it does help people establish their goals and their intent and helps people understand how they want to dispose of their assets. So I say that flippantly, but it does ring very true.
Yeah, I mean, it's a trust. I mean, just to make a little bit light of it, it's a bit haunting, right? You can't have what's called post-mortem control with a trust. You can make all the rules. Those are the instructions in the box. And there are a million different varieties of boxes, like there are at Christmas time, a million different boxes under the tree. They're all unique and can be customized. But if you don't have a trust, and then you're at the whim of the courts and what they decide. So if you want to have control and privacy and some backup, then a trust could be a good option.
What happens if a couple is married, they establish a trust while they're married, and they choose to get divorced?
Well, the property in the trust is established as joint property, would be community property. That's their community property estate. I'm assuming there are no inheritances that were.
Assume it's all community and just walk us through the examples so the clients understand what their options are, because this comes up in our office all the time.
Oh, yeah, sure. So in whether it's collaborative or litigated, the divorce settlement agreement will determine the percentage or dollar value that would be distributed to them. And then if there is a joint account, they're divorcing, they don't need to have a joint account moving forward, then separate accounts would be established. Let's assume they stay at Hancock Whitney and they have a joint account, and then they separate them out to spouse A has an investment account that's 50% and spouse B has an investment account that's 50%. Spouse A then would have one trust advisor. I may not serve on that. Maybe it's spouse B that I continue to serve on. Or maybe we decide that I don't serve on either of them. I have a separate trust advisor for A and for B, and then we continue to manage the investments, but then we need to create a new financial plan. If it's not already one of your planning clients, Jennifer, then we would create a financial plan for them, develop the goals and objectives that they have for this, look at what their needs are. So I'm going to, maybe one spouse did not have, was what we call the non-money spouse. And not only, they now have money, but what they don't have is credit. And so we would use a, maybe make a secured line of credit against what they have to help them build credit and help them get, maybe they want to purchase a home or a car or have the ability to do that. We would do that. They may have charitable interests. And so that's part of their goals and objectives. Then we would establish a charitable foundation for them. We can certainly do that. And put in place any of whatever the new goals and objectives are. If there's a business that was divided and there needs to be liquidity for selling the business, we can do that through lending. And so there are all kinds of tools that we have to bring that I really didn't have when I worked at smaller shops or just investment companies. I couldn't do any of those things.
Mhm.
But I like having the flexibility to be able to pull in other team members to do all of these different things that may be needed and called for and part of the plan.
Absolutely. Well, excellent. Well, if there aren't any other questions in the Q&A, I will make a commitment to repost this webinar and get all your information out to anybody that wants to look at it again or reach out to you. And we are super appreciative of our partnership and time that you take to spend with my clients. So I thank you very much. And thank you for being with us today.
Great. I appreciate it.
Thank you, Sonja.
Thank
Yeah.
you.
You're welcome,
everybody.
Sandy, Richard. Goodbye, everyone.
Bye-bye.
Bye.